I'm a pillarship. I'd like to mention for listing one IML for suspension of sanctions matter. A matter pending since 2024.
When?
Next week, any date? Monday.
Same clear, my lord. And
I for condemnation of delay loss I Monday loss
How many, what? Conviction?
conviction loss. Condemnation of delay.
Friday.
This Friday. Master.
correct. I beg to mention item number 24, my lord, for adjournment, my lord. My senior counsel, his elder brother has expired, my lord.
Oh,
M.K. Sudhir.
Okay, right. And the prayer for adjournment made by the appellate counsel on account of bereavement in the family. This is the matter when? After,
After 2 weeks.
after.
May I please, your lordship? I require 3 weeks time to file my affidavit in reply against the preliminary objection filed by them.
The preliminary objection is, it's a question of law, it's not a question of, fact.
Lordship,
What?
instructions are still awaited
No,
from the
sorry.
department. Lordship.
If you don't have, you cannot keep on adjourning the matter. Yes,
Yes, my lords, on the last occasion, lordships were pleased to find whether the appeal is maintainable before this forum, my lords. We had raised a preliminary objection that under 35G of the Central Excise Act, this appeal is not maintainable before this forum,
let us see 35G.
my lords. My lord, may I kindly take my preliminary objection. I've enclosed the provision for lordships
Oh, yeah.
inconvenience.
Okay.
My lords, have the preliminary objection for appeal 1 of 2025.
Yes,
Yes, my lord. Lordships may kindly come to page 49.
yes,
My lords, page 49, section 35G.
yes,
May I place, my lords?
yes.
My lords, 35G, appeal to High Court. An appeal shall lie to the High Court from every order passed in appeal by the appellate tribunal on or after the first day of July 2003, not being an order relating to, among things, to the determination of any question having a relation to the rate of duty of excise or to the value of goods for the purpose of assessment, if the High Court is satisfied that the case involves a substantial question of law. My case, my lords, is that this question in the present case relates to the rate of duty of excise and the value of the goods for the purpose of assessment. Therefore, under 35G, the appeal should not lie to this forum, my lords. What is the remedy of the department, my lords? It is under 35L. Lordships may kindly go 2 pages hence to page 51.
Yes.
35L, my lords, provides for appeal to the Supreme Court. Lordships have it. 35L1.
Yes.
An appeal shall lie to the Supreme Court from A, any judgment of the High Court, or B, any order passed before the establishment of the National Tax Tribunal by the appellate tribunal relating, among other things, to the determination of any question having a relation to the rate of duty of excise or to the value of goods for the purpose of assessment. My lords, in this case, we had applied for special value addition rate under the Central Excise Scheme, which is an area-based exemption for the Northeast sector. My lords, this particular issue for a similar SSE has already been decided by the Honorable Sikkim High Court, which I have enclosed at page 52.
Yes.
My lords, this is by decision, a recent decision, my lord, of April 2025 by the Honorable Sikkim High Court. In this case also, the issue was whether the value addition rate, which the department has fixed for us, that in that the appellate tribunal held in the SSE's favor. The revenue challenged that appeal before the Honorable Sikkim High Court. The Honorable Sikkim High Court, my lord, noted the provisions of 35G. It's a short judgment, my lord. May I read the facts and the...
Yes, yes, yes.
Yes, my lord. My lord, page 52 at the beginning.
Yes.
This statutory appeal has been filed by the Commissioner of Central Excise Customs and Service Tax, Siliguri, against a final order dated 20th February 2024, passed by the learned Customs, Excise and Service Tax Appellate Tribunal, Kolkata, in appeal number 657 of 2010. The learned CESTAT has held that the respondent is entitled to a special rate of value addition at the rate of 73.5%, which is based on the actual value of the cost of materials and inventory reflected in the audited financial statement. According to the appellant, this observation of the learned tribunal that the respondent is entitled to a special rate of value addition is incorrect and bad in law. Then, my lord, they have referred to 35G1, which I just placed before my lords.
Yes.
After referring to 35G1, my lords, a bare perusal of the above provision clearly reveals that no appeal shall lie to the High Court again from any other order passed by the learned tribunal. If it is an order which relates, among other things, to the determination of any question having a relation to the rate of duty of excise or to the value of goods for the purpose of assessment. Since this matter relates to valuation, we are of the view that this High Court has no jurisdiction to entertain, try, and determine the issue as sought to be raised by the Commissioner. Central Excise Siliguri. In these circumstances, we grant liberty to Commissioner of Central Excise Customs and Service Tax to approach the Honorable Supreme Court of India for redressal of their grievances, if any, in accordance with law. The appeal is disposed of accordingly.
Yes.
So, my lord, this is the same question, a similar question which has been raised in this appeal as well, my lords, where they have said that the value addition rate which has been fixed by the Customs, Excise and Service Tax Tribunal.
Let us see what is the stand of in the appeal. What
My
is
lord.
the stand of the appellant? What have they said?
Very well, my lords.
What is their prayer?
My lords, may kindly come to the substantial question of law which they have read. Page
Yes.
13.
Yes.
The very first question of at the bottom of the page, my lords, the substantial question of law is there. Lordships have it.
Yes.
The first question, my lord, whether the appellate tribunal was legally correct in holding that the issue involved in this appeal is as to whether fixation of special rate can be rejected because the sale value is arrived from the audited financial statement of the company by appropriating the same to the respective units on the basis of the stock transfer ratio or not. Thereafter, my lords,
So
paragraph.
the issue out here is not with regard to the rate.
No, it is with the rate. My lord, what had happened is the commissioner we had applied for a particular rate of value addition. The commissioner had given us a lower rate of value addition. When we approached the tribunal and said we are entitled for a higher rate of value addition, the tribunal agreed with us and held that yes, you are entitled for a higher rate of value addition, which is what they have challenged in this appeal, which is precisely the case which I showed to my lords.
What is the second ground taken by them?
My lords, then the tribunal has followed another order of the tribunal passed in the case of Hindustan Unilever versus Commissioner of Central Excise. They said whether they are right in following this judgment of the tribunal. Paragraph C, whether tribunal was legally correct under the facts and circumstances of the case in holding that the methodology for arriving at the sale value from the financial statement of the company by appropriating the same to the respective units on the basis of stock transfer ratio has been accepted and special rate has been fixed accordingly. So the question relates to whether the fixation of special rate as done by the tribunal, that is correct or not.
What does this CESTAT judgment say?
My lords, in this appeal, they have not enclosed the CESTAT judgment.
We have enclosed, Lordship.
Where?
They have enclosed it in their other appeal.
That is starts with page 25
25.
of the appeal memo.
That's a page 25.
My lords, this is in the other appeal, the excise appeal 2 of 2025. This is not, they have not enclosed the impugned order in this appeal, my lords.
Okay. It's in the other appeal of 2.
2 of 2025, my lords. In that, page 25.
Page
25, my lords. It's
Huh?
the 25, 25.
No, but this 25 is with regard to Johnson products, SC Johnson products. This case mentioned at page 14 is MS Hindustan Unilever.
Oh, my lord, that ruling they have not enclosed. I have also not
That we
submitted.
have not enclosed.
So you said you have enclosed.
Yeah, I have enclosed the sestate order that I have mentioned.
You see, tribunal has decided the same issue in MS Hindustan Unilever Limited. Where is this?
That we have not annexed.
Why?
Lordship.
But how am I going to look at it? You have mentioned it here. Where is it?
That is not with me right now, Lordship.
Now,
Lordship,
now
may
you-
have this matter on Friday, Lordship. Mr. Cal will have his submission and Lordship he will
where is
satisfy
Mr.
by,
KL?
Lordship is on legs in court number 1, Lordship.
We'll wait for him. Get the judgment in the meantime.
Lordship,
We'll wait, we'll get after some time. We'll take it up at 2.
Lordship.
Get the judgment. He doesn't come there.
May
See,
the application,
this is an appeal,
yes, appeal
right?
on the section. And then, but
In the Upadhyay, learned counsel for the appellate will submit that. The impugned judgment order dated 19/9/25 passed by the Sessions Judge Dibrugarh in Sessions Case number 230/22, by which the appellants have been convicted under section 302/34 IPC should be set aside. Admit the appeal, call for the TCR. Ms.
SH Forum.
S.H. Bora appears for the state. This is the matter after 4 weeks.
There's an
Ms.
IF bail.
Ms. S.H. Bora,
after,
the learned APP is granted 4 weeks time
Lordship.
to file written objection to the application under section 430 BNS. This is the matter after 4 weeks.
Obvious.
Yes, so paper book has not been made,
Lordship.
so we have got to wait. Right. This is the matter after 3 weeks, in as much as paper book has not been prepared despite orders to the said effect having been issued earlier.
Lordship may fix the date, Lordship, after 3 weeks. Any date.
Date, after 3 weeks.
Keep your Lordship.
In this case, my lord, on last occasion, I was directed to take one instruction, my lord, regarding, first, my lord, one learned friend stated that, my lord, one of the accused in appeal number 180/24.
yes.
Yeah.
Yes, my lord, he is no more, my lord.
Okay.
So, my lord, here I am yet to receive the instruction. Can it be fixed day after tomorrow, my lord?
We got the certificate.
My lord, maybe that may be perused, but I have not received the instruction till yet. My lord, day after tomorrow if possible.
Okay, right. Mr. H.R.A. Chaudhary, learned counsel for the appellate is present. So, sir, he submits that.
I am not submitting. Oh,
Huh? He has died.
yes.
Then, yes, submitting that.
Yes, I am not in that case, madam.
Oh,
Yes.
that is present, huh? Then put up. Miss KM Saikya. the learned counsel for the appellant in criminal appeal 180 of 2024 submits that the appellant MD Raman Ali has expired on
Uh,
22/9/24.
22/9/24.
22/9/2024. And in this respect, give me that. Certificate, death certificate. Dated 8/1/2025 has been issued by the Registrar Births and Death, GMCH, Guwahati. Mr. R. Kaushik, the additional APP, submits that he will obtain instructions with regard to the above. List the matter on when
Day
tomorrow,
after third.
Day after-
Let it tomorrow.
Well, day after tomorrow, it will be better.
Friday. It is also just, have you got the paper book?
Yes, yes.
Houses for the parties also submit that they have received copies of the papers.
Problem. Yes. This case, matter POXO is there and informant party is also here, madam.
Paper book is ready this week.
Respondent, one respondent,
Respondent number 1 and 2.
There are two respondents. Lord.
or 1 and 2. So, okay, so without taking steps, they have appeared.
Actually, Lordship, we have handed over, there was an IA which has been allowed and in the hearing of the IA, they appeared
Okay.
and we supplied a copy, but in the record, it is not been shown.
So what is to be done?
So we'll,
Please the case after 4 weeks.
Okay.
Lordship, if they want, we can supply another
Lordship,
copy.
the
but-
appeal memo was not,
Appeal memo not, so it will be given. File Vakaladama.
yes, Lordship.
Okay, right. Mr.
D. Bharadwaj.
D. Bhardwaj appears for the NIA. Miss
L Das, lead us.
L. Das appears for the respondents. Two
Respondent number 1 and 2.
respondents for the respondent number 1, for the two respondents. And submits that she has not been given a copy of the appeal memo. The counsel for the NIA submits that he will provide copy of the appeal memo during the course of the day.
Yes, Lordship.
During the course. The counsel for the respondent is granted 4 weeks' time.
Yes, Lordship.
Lordship, if the time period may be fixed after 2 weeks, actually, the main fact is that the actual court records are here. That is why the trial
Lordship,
proceeding has not been conducted.
Oh.
Because in this case, there are around seven accused persons and the trial is has not been proceeded from the month of July. Because the original case records are here.
Lordship kindly fix this matter after 3 weeks.
Okay, 3 weeks' time, huh?
A
And
date
3
may
weeks'
be
time to
fixed,
file
Lordship.
written objection.
A date may be fixed.
Okay, written objection. As TCR has arrived, list the matter on, give a date.
Much obliged, Lordship.
Obliged, Lordship.
Register to reflect the name of the respondents counsel in the cover. So respondent number 2 has been served.
Lordship, I don't think so because I don't have, because I don't have anything to show my lord.
Acha, okay.
Notice who said it?
I don't have any objection.
No objection file ko nila mo chabon mo. Wala na pinto din.
Okay, right. As per office note,
Ito mo haran ko kung dito.
the TCR has not been received. Full stop. Ms. B. Buyan and APP shall obtain instructions with regard to Service of notice upon the respondent. And this is a matter after 2 weeks.
Lordship will take steps on the victim.
Already taken, you have to give a report. Actually, in the IA, right, in the IA, written objection has been filed by the state. Any objection, madam? 151 days.
Delay, Lordship, let it go.
Mr. Anshuman Das, learned counsel for the applicant, submits that there is a delay of 151 days preferring the appeal against the conviction of the
Steps.
applicant under section 6 of the POCSO Act. Ms. B.
Lordship, the name would be R. Bhuya, Lordship, not Mr. Anshuman Das, for the applicant.
R. Bhuya.
Yes, Lordship.
Your name is R. Bhuya.
Yes, Lordship.
Appearing on behalf of Edar.
No, Lordship, on behalf of Mr. P.K. Bhuya, Lordship.
Okay, I'm down.
PK Bhuya's name is shown.
PK Bhuya. Okay, PK Bhuya. Ms. B. Bhuyan, additional PP, submits that she has got no objection to the application being allowed. Accordingly, the delay of 51 days is condoned. And this leaves the appeal. I accordingly dispose of.
Wait, Lordship.
Yes, madam, are you filing?
Lordship 14.
WO.
No, this is a fresh case, I think.
Fresh case, me?
This is a fresh case?
Yes.
Paper is ready.
No, this is not a fresh case.
No, the IA is the fresh.
A fresh,
Wait, then we don't have a copy of
okay, then right. Ms. B. Bhuyan is granted 4 weeks time to file
my lord.
written objection to the application under section 430 BNS. Please the matter after 4 weeks.
Lordship.
Then in the main case, you write. As the paper book has been furnished to the causes for the parties. Please the matter for hearing when? Tomorrow, day after,
I don't know. Next week.
next week.
No, then he should not place.
Since she is going to file this objection.
No, she's not going to file. If we can finish up the.
Yes.
Higher.
Meant to call is meant to call.
Then next week, Lordship, your Lordship fix the matter.
It is 302, na?
302.
We will not file our objection.
Okay, next week. Then in the objection, you say you withdraw the objection. You withdraw the.
Aye.
Okay, right.
Let it be, my lord, as it is.
No, we'll dispose it of. No point keeping it pending. In the IA, right? Mr. B. Chetri appeared for the applicant, while Ms. B. Bhuyan, APP, appeared for the state. As the main appeal has been fixed for hearing in the next week, the IA has become infracted. IA has become infracted on account of
The submission be recorded.
on account of Mr. B. Chetri trying to withdraw the IA. The IA is accordingly disposed of as infracted on being withdrawn. Then accordingly dismissed as withdrawn. Next week, for the.
Hearing.
My lord, in the meantime, my lord, the accused person is suffering, seriously suffering, my lord. That medical report is necessary, my lord.
Then
He will
both the
get it.
things won't go, my lord. He wants hearing at the.
We will dispose of the main case.
Lordship.
Whether if you are suffering, then they will look after you from jail. Or if you need to go to the hospital, you'll go to the hospital.
They are not supplying the medical documents. That is the problem now. Whatever it was happened, my lord, it was not been informed to the accused family members. Only they have come to know they are running here and there.
There is some eyewitness in your case.
There is no eyewitness.
No.
No eye.
Next.
Lordship.
So paper book has to be made.
Already I have got the paper.
No, no, not in here. 15, 16.
15, 16, yes, DCR.
Yes,
Right.
15, item number 15, that paper book needs to be
Made.
prepared.
Yes.
And written objection has to be filed.
Yes.
Written objection also not filed. And in the item number 16, Lordship, this is Lordship cross case, Lordship, where the accused persons were acquitted. Against that acquittal order, this appeal has been filed, Lordship. So in that case, Lordship, that appeal needs to be admitted and records may be called for, Lordship.
The same record.
No, that is a different case, cross case, Lordship. The case which this accused persons filed, Lordship, this appellant's filed in item number 15.
No,
There are two cases, Lordship.
Correct. So
One filed by us and one filed against us. Which was filed against us, we are convicted, that is appeal number 15.
correct.
Which we are received, Lordship. And the case which we filed, Lordship, the accused person was acquitted, that records are not before your Lordship. In item number 16.
No, so two different cases.
Two different cases.
No. Okay. In this item 5th, you're right. Miss S.H. Bora,
Yes, Lordship.
the APP is granted how much time?
Lordship, 4 weeks time may be granted.
4 weeks time to file written objection. To
Can
the
it be, Lordship,
application under section 430 BNS.
Can it be 2 weeks or 3 weeks?
4 weeks.
Always. Push up. As TCR has arrived in Criminal Appeal 351 of 2025, registry to prepare the paper book. Now give me the other.
Not nice.
Item 16. Heard Mr. M.A. Chowdhury, learned
Yeah.
counsel for the,
Yeah.
Yeah, Mr. A. Ahmed, learned counsel for the appellant, who submits that the judgment dated 3/6/2025 passed by the Sessions Judge Kokraja in Sessions case number 53 of 2012, by which the appellants, by which the respondent, no, by which the respondent's number,
Respondent number 2 to 8.
2 to 8, have been acquitted, should be satisfied. Admit the appeal. Call for the TCR. Ms. S.H. Bora accepts notice on behalf of the state.
May I pray, Lordship, that
Issue notice, returnable in 4 weeks. Ms. S.H. Bora, APP accepts notice on behalf of respondent number 1.
Lordship.
Appellant to take steps for service of notice upon the respondents number 2 to 8 by speed post within 3 days.
May I pray that this notice to private respondents may be served through the concerned court, Lordship, in terms of section 437A, Lordship. Because in terms of 437A, once a person is acquitted, he has to submit, he has to take bail, Lordship, to appear before the next appellate court if appeal against conviction is acquittal is filed, Lordship. So they are on bail till now, Lordship. So if it is served through the
Bail, they've been acquitted, there's nothing remains.
after acquittal in terms of 437A CRPC, they have to take bail, Lordship, to appear before the next.
Not applicable anymore.
Lordship, may I kindly say 437A CRPC, Lordship.
No, let us see the BNSS. What has
In BNSS is also there.
when did BNSS come into when did it come into thing? When did it come into force? BNSS?
We are 2024.
24.
24.
So this judgment was of 25.
25.
So
But
let us see BNSS.
430 के बाद 7
437A.
है Thank you.
That is 481 now, Lordship, in BNSS.
No, this is nothing.
Not their lordship.
No, they are already on bail so that they can.
They have been acquitted. There's no question of
No,
bail.
that part has been interpreted by division bench of our High Court. Lordship.
Sorry, I don't know. You show me that. That's all. List the matter after 4 weeks.
Lordship, a copy of the appeal that may be furnished to us, lordship.
That already we have started.
Secretary, lordship, that is not there. That big one. Okay.
Outline.
Then 70. Huh? He's talking about those persons who have been convicted.
May I please, your lordship?
This is a wrong submission.
May I please, your lordship? So appeal against conviction, man.
Huh?
There is a delay of 453 days, man.
Okay, right. Any objection, madam? Mr.
D. Bora, man.
D. Bora. Submit that there is a delay of 4-5 days. The appeal against the conviction of the appellant. Conviction of the applicant under section 147, 148, 323 /149, 324 /149, 326 /149, 302 /149. Ms. S.H. Bora, additional PP, submits that has got no objection to the delay being put. The delay of 453 days is condoned. I register to list the appeal. I accordingly dispose.
There are similar appeals, my lord. I have even that may be take.
One at a time.
That may be take together, my lord.
John?
There are similar appeals, my lord. Criminal appeal 54/24.
Okay, registry to list this appeal along with criminal appeal number
74/24.
74/24.
Criminal appeal 121/24.
121/24.
Criminal appeal 211/24.
211/24.
My lord.
Huh?
I have mentioned in the IM, my lord. My lord.
We whatever you have said, we believe you.
My lord. Obliged, my lord.
Heard Miss
Arbegum.
name.
Arbegum.
Heard Miss R. Begum, learned counsel for the applicant, who submits that there is a delay of 8 days in filing the appeal against the conviction under section 6 of the POCSO Act. Mr. R. Kaushik, there's got no objection to the delay being condoned. Accordingly, the delay of 6 days is condoned. Registry to list the appeal. I is accordingly disposed. The item 19, Miss S. Khatan, Legal Aid Council, 81 days, POCSO, 81 days. Okay. Yes, madam, what's your name?
F. Shaheen, your lordship.
Huh?
F. Shaheen, appearing on behalf of BK Sen.
Ms. F. Shaheen appearing on behalf of Mr. B.K. Sen, Legal Aid Council. 89 days, 302, IBC.
Much.
Supplementary order, 1925.
Paper book is not ready.
And in this case, Lordship,
No written objection also filed.
My lord, paper last occasion, my lord, there is an order for paper book, my lord, preparation. Paper book, my lord,
Correct. Paper book not made.
not made, my lord. So
You want to file a written objection to the application?
yes, my lord.
and in Lordship, I have also taken the plea that the petitioner is, Lordship's appellant is seriously ill and needs immediate operation of his eye, Lordship.
Aye.
So Lordship. I have enclosed some documents, Lordship, that he was produced in the hospital from jail, which is not sufficient, Lordship. Page 74, Lordship, will find onwards. So a medical report may be kindly called for, Lordship, regarding his status, health status.
OPD number, there's no OPD number. Hospital. 6/6/25.
Yes. After that also there are some,
6/6/25.
these are the some of the documents which Lordship, we could collect when he was brought to the hospital. So other documents will be with the jail authorities. So one report may kindly be called for and that will review, Lordship.
He will obtain instruction.
Lordship.
My lord, order, copy of the order may be given because I don't have any file with me, my lord.
Which order?
Today's order, my lord.
You download it from your computer.
My lord.
You don't have computer.
I have, my lord.
Then everything you need to be sent. Right. Mr. A. Ahmed, learned counsel for the applicant. Pays for suspension of the sentence in relation to the judgment dated 11/3/25, passed in sessions case number 176/2022, by which the learned session judge Barpita had convicted the applicant appellant under section 302/323/34 IP. Next para. Mr. A. Ahmed also submit. There is no interim prayer, nothing.
No, I am not praying for interim. This is IA, Lordship. IA filed for suspension of sentence and in the meantime report.
What is that? The applicant is suffering from cataractus changes. This is in para 7, huh? Cataractus changes in the right eye, for which the doctor of FAAMCH, Barpita, had advised surgery. In this regard, he has relied upon the medical OPD card dated 6/6/2025. And other document. Mr. R.R. Kaushik, the learned APP, shall obtain instructions with regard to whether the applicant needs eye surgery and the seriousness of the ailment being suffered by the applicant. He is also granted 3 weeks time to file an objection. Leaves the matter after 3 weeks. Good it.
Can it be also 2 weeks now, considering his?
Yeah, June, suddenly you're going to what? It's going to be very serious. After 5 months, it's become serious.
My lord, paper book may be provided, my lord, because it's not been ready unless there is.
That's why in the main case, you're right. As the TCR has arrived, registry was to prepare the paper book. However, the same has not been prepared.
Yes, ma'am.
As and when the same is prepared, registry to furnish the paper book to the parties. This is a matter of 3 weeks.
Other side is not there. Your lordship heard at length.
I don't remember. Did I make any notes?
No, probably not, my lord.
No.
Lordship, my senior is in another court. So pass over for the time being.
The POXO matter,
Credit is what? You see, we have got a part-heard matter, Mr. Ahmed. Okay, that item 21, already part-heard matter.
In that case, may I pray for a fixed date?
Ah,
next week?
we have fixed it. 21 is there because we have heard him sometime back. So 21 on the, or 23 on the prayer of the parties, list the matter on?
On 20th, no,
Huh?
on 20th next week.
It will be difficult. 25th.
No, wait. Okay, 25th, okay, we'll try. Okay, 25th, huh? Okay.
25th.
Problem. Huh.
Obliged.
Let's go.
So if I beg to apologize if I was in.
No problem, no problem. The only problem is we don't remember what was said earlier. Everything gone. So we'll have to start from the beginning. Did we make any notes? Did I dictate? Did I make any dictation last time?
No.
No, no. Usually I make some dictation so that I remember. I don't remember anything. Anyway, let's start.
Your Lordship, this is the case filed by her mother against my accused person, Your Lordship. And accordingly, they went for, I just retrospect my memory and collect. They went for Holi. There is a Holi, pre-Holi at Shivsagar Sivodol. The girl, the victim went to the Holi for celebrating Holi with her girls. And thereafter they went there. After being noticed, her mother came to know that she has not returned back to her home. Then she has lodged an FIR. After being lodged in FIR, she has been discovered dead. Whole night, her daughter was not available at her home. And in the morning session, at the morning time, she got a phone from her victim, from her daughter, that one so-and-so has raped me for 4 times.
But see, here we preferred appeal. Notice was issued to the respondent. They raised a preliminary objection that appeal lies to the Supreme Court, not to this honorable court. But if I require some time to file my objection to that appeal.
You see, the issue raised by them.
Yes, sir.
Is in a very narrow compass. Whether the issue pertains to the rate of value addition
Not.
or not. If it pertains to the rate of value addition, then that cannot be decided by this court.
No, Lordship, here, Lordship, may please to see the original order. Their application was rejected on the ground that the figure was not matching. It is not the case of the petitioner that we have not saying that they are not entitled to special rate. They are entitled to special rate, but Lordship may please to see page 24, paragraph 2.1.
Paragraph 24.
With page 24. Lords. We are not saying that they are not entitled, but the figures they were submitted to the authority, that was not as per the notification. They completed to their.
Whatever be the numbers, it will be that issue will be decided by the court, by the
Lordship, here, Lordship may please to section 35. Lordship.
35G.
Yes, Lordship. 35G.
Yes.
Married Lordship. They quoted in their objection also.
Page 57.
An appeal shall lie to the High Court from the every order passed in appeal by the appellate tribunal on or after 1st day of July 2023. Now, not being an order relating, among other things, to the determination of any question having relation to rate of duties of exercise or the value of the goods for the purpose of assessment. This is the exception, Lordship. But
Correct.
But Lordship, here, Lordship, at least to see why that application was rejected. Not on the ground of fixation of special rate. It was rejected because their figures were not matching to each other.
Correct. So according to you, what is the special rate of value addition that they're entitled to? According to you?
They have to file audited balance sheet as per and the report of the chartered accountant. On the basis of that, Lordship Department calculates. Lordship, please to see paragraph 2.2.
Of your affidavit.
My application, Lordship, my appeal, Lordship, page 24.
Where?
Paragraph 2.2. I find that the appellant company is having multiple units.
2.2?
Yes, 2.2, page 24.
Oh, 20. This is the CESTAT judgment.
Yes, CESTAT order. This is the order passed by the original authority.
By the original commissioner.
By the commissioner, my lords,
Commissioner Central Excise.
Commissioner Central Excise.
Against that.
That is against you. That is in favor of you.
In favor of you. Thereafter, they approached the CSET, that order was passed.
That 2.2 says where?
I find that the appellant company is having multiple units and the goods manufactured in multiple units are transferred to CNF agent and for sale of customers. Thus, the actual value of the sale of products manufactured in particular unit is not determinable. The next paragraph. The exemption under notification 32 of 99 dated 8/7/99 is applicable to a unit located in area specified under the said notification. As such, the benefit of refund at the special rate representing actual value addition to a particular unit is only available. The special rate representing the actual value addition in respect of the unit can only be determined on the basis of actual sale value, actual cost of raw materials and packaging materials consumed in said unit. Lordship, now our objection is
reading, continue reading.
Lordship. Actual value of the convertible fuel consumption in the unit and actual value of the opening stock and closing stock of finished goods laying in the unit during the preceding financial year. In present case, the appellant has determined the sale value by way of allocation apportionment of the total sale value of the company having multiple units on the basis of central excise duty paid by unit. Sale value determined on the way of allocation appointment of on arbitrary basis cannot be constituted as sale value of the purpose of determination of special rate representing the actual value addition under the said notification. Thus, I hold that the special rate representing the actual value addition under notification 32 of 99 in the respect of the appellant unit cannot be fixed in absence of actual figures. That was the reason that their application was rejected. Not that they are not entitled to special rate. Our contention before a lordship is that they have to submit the sale value of each unit, not multiple units in a one go. So there is no question of determination of any taxable value that specified in section.
So he rejects the application for fixation of a special rate on what ground?
Ground that lordship they submitted their figures on multiple units because they are two units, unit 4 and unit 6. So they have to submit application separately, not consolidated. So this is not a question of lordship fixation of lordship provided under section 35G. And lordship, I have submitted one judgment of Supreme Court 2019 9 SCC page 563. This is with relation to Custom Act lordship, but the provision is same. Paragraph 9 and 10 lordship.
There,
Paragraph 9. That judgment, Lordship.
there.
May I read it? Upon a conjoint reading of the aforesaid provision it could thus be seen that an appeal lies to the,
Okay, that is paragraph 11.
yes,
You are reading from what? Manupatra?
Lordship, Supreme today, Lordship.
Supreme today.
Probably paragraph may vary, Lordship.
Para 11.
Upon conjoint reading of the aforesaid provisions, it could be thus seen that an appeal lie to the High Court against every order passed in appeal by the appellate tribunal. If the High Court is satisfied that the case involves substantial question of law, the only exception carved out is that the appeal shall lie before this court and shall not lie before the High Court against the order or relating, amongst other things, to the determination of any question.
To the
having-
determination of any question.
Any question of duty law.
Having relation to.
Yes, in having relation to determination of any question having relation to rate of duty of custom laws.
Correct.
So we are not, Lordship, disputing that they are not entitled to special rate. Our contention is that they file a multiple.
No, but then it says here, the Supreme Court has said,
Yes, Lordship.
among other things, to the determination of any question relating to the rate of duty. Now, you see, how the rate of duty has to be calculated is an issue that has relation to the rate
No, Lord.
duty.
Here, Lordship, notification is there. Notification is specified that they submitted their details of financial statement as per unit laws. They submitted consolidated there because they are having two units, unit 4 and unit 6. They submitted the application, consolidated application, Lordship. So the figure was not matching. That was the reason, Lordship, their application was rejected.
So they should file separate applications for
Yes.
each unit.
Yes, Lordship, this is our main contention, Lordship.
You file separate applications for separate units. What's the problem? Mr. Counsel, for the respondent?
My lords, the commissioner in his order has held that the sale value which has to be determined for fixation of special. What is this fixation of special rate, my lord? If I may just clarify, my lords, we are entitled for exemption under notification 32 of 99, excise duty exemption. This was subsequently amended by subsequent exemption notification. They said that the notification has a rate of exemption which is applicable to you. So suppose the rate which is provided in a notification for us is 34%. We are entitled for exemption for the value of the goods pertaining to 34%. The notification provides that in case your value addition is more than 115% of this, you can apply to the commissioner and seek for an enhanced value. We say in our case is that our value is more than
Value will be
100.
how much?
My lords?
Enhanced value will be how much?
My lords, enhanced value will be approximately 64%, my lords. So that was the matter which we approached the commissioner. The commissioner rejected our application. We went to the tribunal. The tribunal said, yes, you're entitled for 64%. My case, my lords, is that if I am eligible for this value of 64%, whether I'm eligible for 64% or I have to go revert to the original rate of gain mentioned in the notification pertaining to 34%, that is a question relating to the value of the goods which is pertaining to assessment. It is not about rate of duty, my lord. It is for the value of the goods for the purpose of assessment, which is prohibited under 35G and 35L, my lord. That is my submission. That is why in fact, my lords, in my affidavit, I brought my lord's attention to a recent
So in your case, it pertains to the value of the good, not the rate of
value
duty.
of the goods for the purpose of assessment. Yes, that is my case. My lords, in fact, I apologize.
Yes.
My lords, I brought my lord's attention to a recent Sikkim High Court. In the next page, my lord, there is a Jammu and Kashmir High Court, which also says that for exemption notification, whether exemption notification applies to an assessee or not, that is also a question whether for value of goods for the purpose of assessment, it is barred. My
Okay, just for argument's sake,
my lords.
He says that you had applied for this exemption.
My lords.
on a consolidated application for 2 units.
My lords,
Is it so difficult for you to make separate applications for the separate unit?
separate application. My lord, may kindly come to the substantial question of law which they have raised. राहुल को मैसेज करो. हाँ. टीचर के सामने केस किया था. The first substantial question of law, bylaws pertains to the sale value. What is the sale value? This sale value is for the arrival at the value addition application. We have taken a median line for approaching the sale value, for arriving at the sale value. We have taken our pan-India value and we have divided it with the total amount of sales and arrived at the sale value. Their case is not that you have given one application. They are saying whether it can be on the basis of the your annual financial statement, you can arrive at the sale value or not. It is not a case that one unit has given for all the units. That is not the case. When one unit has given this application for value addition, to arrive at this quantum of sale value, which is a prescribed methodology under the notification, we have taken our pan-India sales and arrived at the sale value. Their case is not that for one unit has supplied for 3 units. You have given the application for special value addition for 3 units. That is not their case.
No,
It is
their
only-
case is that the sale value of the 2 units have been made in one application.
Yes.
No. The sale value, while we are arriving at the sale value,
You
we have
make
taken-
separate applications.
My lords, we have made one application, my lord. Per unit,
No,
one
why don't you make separate applications
We
for-
have made one application.
for each unit?
We have made one application, my lord. We have not made separate applications.
Why don't you make separate applications?
My lord, that is what I'm saying. We have made separate applications for separate units. We have not made a consolidated application.
Then, yes, he says that he has made.
Lordship, I'll produce the original records, may fix next week, Lordship. Whether there is one application or two, it is specifically written in the order of the commissioner that for multiple units, they submitted one application. And notification provides
Said that?
the unit wise.
Where does it say that?
I find paragraph 2.2, I find that the appellant company is having multiple units and the goods manufactured in multiple units are transferred to CNF agent for the sale to the customers. Thus, the actual value of the sale of the products manufactured in a particular unit is not determinable.
No, but then this does not say anything.
Lordship,
It
next
does not say we have made separate applications, my lord. Only for the computation, for the purpose of
Before,
computation,
Lordship,
we have taken weighted average.
the reason behind not submitting the separate application because the one unit does not qualify as per the notification. That is the reason, Lordship, they have not filed separate application.
No, where does it say that?
Lordship,
they have-
Lordship,
My
please-
lord, that we have made separate applications evident from the 2 appeals filed. That is why 2 separate orders were passed by the commissioner. If there had been one application, there would be one commission.
No, so the present case that we are dealing with pertains to which unit?
Lordship, there are
Is
consolidated unit 4 and unit 6.
No,
Unit
so this
4 and
present
unit 6.
application that we are dealing with pertains to which unit?
Lordship, this combined order was passed. But the paragraph 2.3 is very clear.
My lord, 1 is for unit 6. Appeal number 2 is for unit 4.
There are 2 appeals because one order was filed by the commissioner. Then they prepared 2 appeals. Then the consolidated order was filed by the CSET. So we prepared 2 separate appeals.
Let us see 2.3. What are
The exemption under notification 32 of 99, dated 8/7/99 is applicable to a unit located in the area specified in the said notification. As such, the benefit of refund at the special rate representing the actual actual value addition to the particular unit is the only available special rate representing the actual value addition in respect of units can only be determined.
such benefit of refund of the particular unit
Unit lordship.
is only available.
That is the region lordship, it was rejected. Particular unit only available, special rate representing the actual value addition in respect of unit can only be determined on the basis of actual value, sale value, actual cost of raw materials and package materials consumed in the said unit, actual value of the convertible fuels consumed in the unit, and actual value of the opening stock and closing stock of the finished goods laying in the said units during the preceding financial year. In present case, the appellant has determined the sale value by way of allocation appointment of the total sale value of the company lordship, having multiple units on the basis of central excise duty paid by the units. Sale value determined on the way of allocation appointment of the arbitrary basis cannot be constituted as sale value for the purpose of determination of the special rate representing the actual value addition under the said notification. Thus, I hold that the special rate representing the actual value addition under notification 3299 dated so and so in respect of the unit, that unit cannot be fixed in absence of actual figures. So let's see, my question, let's see, what prevented them to submit the actual value of the units, let's see, to respective units. And this is a region, let's see, because they could not submit the separate value, that will not qualify as per the notification. That the region, let's say, they are not submitting separate rates.
Hello, may I point out one thing? For the subsequent periods, we have followed the same methodology. The commissioner has allowed our claim, which remains unchallenged. This is referred in the CSTAT order itself.
Where?
My lords, may kindly come to the order of the CSTAT, which is Lordship have appeal number 2 of 25.
Yes.
2 of 25, my lords. It's page 25, the CSTAT order starts.
Yes.
May kindly, my lords, may kindly come to page 3, page 27, internal page 3 of the CSTAT order.
Yes.
Paragraph 3, bottom of paragraph 3, my lords.
Yes.
However, it starts, however, since.
Yes.
Bottom of paragraph 3. However, since the actual valuation in the manufactured good was much higher than the percentage specified in the notification, the appellant applied for fixation of special rate for 2009-10 for unit 4 and 6. The Commissioner of Central Excise Guwahati, after verifying the documents submitted by the appellant, fixed rates for the financial year 9-10. 3.1. The appellant followed the same methodology for fixing the special rate for subsequent financial year of 10-11. The details of the special rate which our appellant applied for is extracted as below. Next paragraph, my lord, 3.2. The learned commissioner has rejected the application of special rate by the appellant on the ground that while applying for fixation of special rate, the appellant has determined the sale value by allocation and apportionment of the sale value of the company having multiple units on the basis of central excise duty paid by each other.
Again, I'm reading, Lordship. 2 units were separately assessed, Lordship. They have not filed multiple application, Lordship.
We have filed one application. The question is whether by submitting the application, what is the
allow me
mechanism
to produce the original records, Lordship. I'll produce the original records, Lordship may verify. If you are wrong, Lordship, then dismiss our appeal.
In this item 1, this appeal 1, the period for which this value addition rate is the issue pertains to which year?
9-10, 2009-10, my lord.
9-10, Lord.
2009-10.
Both of them are pertain to 9-10, my lords.
2009-10. So according to you, the subsequent applications made for this value addition rate has been allowed.
Has been allowed, my lord.
Has been allowed, though the manner in which you have made the application is the same.
Yes, my lord.
Yes.
Lordship, allowed to produce the original records, Lordship, verify the records. If that is contention of my land reference is correct, my appeal will be dismissed. My contention is that as per the notification, they have to file separate application for both the investors. And the case of the petitioner is not that they have filed multiple application. But in the present case, they file one application for multiple units.
But in any event, when you look at section 35G,
My lord.
now the issue is whether the determination of the question that you are seeking to raise now, with regard to filing of multiple applications or a single application pertaining to each unit, doesn't it have a relation to the value of goods?
Yes, Lord. This is, yes.
Then if that be so,
Clearly, my lord.
if that be so, why whether this appeal is maintainable?
Yes, Lordship, it is maintainable because all the
Maintainable.
Lordship Supreme Court judgment.
Let us see. It says here. It says here.
Yes, Lord.
It says here. Come.
Lordship, please to see.
There.
Paragraph 9.
11. According to you, it's para 9 or something here.
Yes, Lord. The High Court, relation to the
Conjoint reading.
upon conjoint reading.
Come here. The only exception.
Yes.
Yeah.
Only exception carried out
What is that?
appeal shall.
An appeal shall lie before this court, means Supreme Court.
Yes, Lord.
Before the Supreme Court, and shall not lie before the High Court.
Against the order
The order relating, amongst other things,
to the
to the determination of
any
any
question.
question.
You see, any question relating to Lordship.
Amongst
rate
other
of
things.
duty.
Well, will that any question relating to the rate of duty of customs or to the value of goods? Now, what the issue here is with regard to the valuation of the goods, whether it should be 34, 31% or 64%.
That is immaterial.
How is it relatable? It is relatable because of the applications. According to you, it should be separate applications.
Yes, Lord.
There are multiple units.
Yes.
On the other hand, even if it is separate units or multiple, I mean, if it's separate applications or multiple applications, when the subject matter is how to calculate the value of the good, why is in section 35 not applicable?
Because Lordship, their specially determined as per the notification 3299 Lordship.
Correct. 3299 has to be read in conjunction with 35G.
No, Lordship, here, Lordship, please to see further. Paragraph, next paragraph. It could thus clearly seen that only if question having relation to rate of duty is involved in an appeal or in relation to value of goods of the purpose of assessment, the appeal would lie to the court, and in other cases, it would lie to before the High Court.
Having relation. But what about their second submission, that the subsequent their subsequent valuation addition applications were accepted by you?
That's why I have submitted Lordship, I am allowed to produce the original records. If Lordship, there is a single application for multiple units, then my appeal will dismiss Lordship. But my contention is that Lordship, as per the order passed by the Commissioner, they filed one application for multiple units. So it will be difficult for the department to.
Even for the subsequent years.
Yes.
But what about this order?
Well, it's for the prior. I have small correction, my lords. It is for the prior period which was allowed.
Oh, for prior period.
2009-10 it was allowed. Our period is 2010-11. I stand corrected. I apologize, my lord. For the prior period it was allowed.
12-13.
9-10 it was allowed. Our period is 10-11.
So it was not allowed subsequently.
Yes, yes.
Let's say fix next week, I'll produce the original record.
No. So that issue was. Now you have. Okay, what about the earlier period was allowed, they said?
Lordship, same question, Lordship. If their contention is correct, then my appeal will be dismissed on that contention only. Or it will lie to the Supreme Court under section 35L.
35G.
G or L before Supreme Court laws. Their contention is that appeal is not maintainable before this because
of 35G.
35G Lordship exception is there. If it is determined, the question of duty is determinable, then appeal lie to the Supreme Court under section 35L. 35L up to the Supreme Court.
So he says that we will bring the records.
Very well, but may I just point out one thing, my lords? Their question of law is not whether multiple applications have been made. Their question of law is whether the sale value has been correctly determined.
Probably my
Whether-
learned friend does not read out the entire question of laws, I submitted laws.
While arriving at the sale value, whether I can take the consolidated accounts and do appropriation. That is the question. It is not, the question is not whether multiple applications have been made by the SSC.
Respective units, but if it is very much, it is there.
Yes, that is for appropriation, my lord, but application, multiple applications have been made is not the question. The question is, while determining this valuation, whether I can take the pan-India value and appropriate a particular value to my unit. That is the question raised, not whether multiple applications have been made.
See, yes, I think, you see, I think he's got a point. Is it to the determination of any question having a relation to the rate of duty? So it does not only pertain to the rate of duty. It,
Amongst other things, ma'am.
any question that has a relation to the rate of duty. So this is a question relating to the rate of duty. It is not per se, not directly on the rate of duty, but though it has a relation, but it encompasses more. It has any question that has a relation to the rate of duty.
Lordship, regarding interpretation, Lordship, Lordship is a.
The phrase used, my lord, is among other things in this provision.
Correct, amongst other things. Yes.
Among other things. So there can be 10 other things, but if any one thing pertains to the valuation or to the rate, the jurisdiction is excluded, my lord, is my humble submission. My lord, other than this Sikkim High Court, which I showed, my lord, in the morning, there is a Jammu and Kashmir High Court also in the context of exemption notification, which has that the in cases of interpretation of exemption notification, 35G cannot be invoked. It is in my opposition, in my preliminary submission, my lord. Page 61 is the Sikkim High Court order, my lord. Page 63, my lord, I am arguing from the 2 of 25, the preliminary objection made into appeal number 2 of 25.
Yes.
Page 63, my lord, is the Jammu and Kashmir High Court.
Yes.
My lords, similar to an area-based exemption.
Where's the relevant portion?
My lords, para 15, my lord, page 66. Para 15, they are talking about the interpretation of 35G. Subsequently, my lord, para 18, my lords, can you kindly come to para 18, page 68.
Yes.
My lords, after going through the provisions and some decisions, they have said it was opined therein that the question of exemption is directly and proximately relating to the rate of duty for the purpose of assessment of excise duty payable by the SSC. Hence, jurisdiction of the High Court to entertain the appeal would be excluded. Similar views was taken by the division bench of the Uttarakhand High Court in the case of Tirupati LPG Supra. From the above referred judgment, it is evident that it is the consistent opinion of the courts is that the dispute as to whether or not the SSC is covered by the exemption notification relates directly or proximately to the rate of duty applicable thereto for the purpose of assessment. Hence, high courts will not have jurisdiction to entertain appeal pertaining to that, it being exclusive jurisdiction of the Honorable Supreme Court. Explaining the issue as to how the case involved valuation for the purpose of calculated duty, it was initially submitted that the exemption was in total. However, later on the same was reduced only to the extent of value addition, which is my case, my lords. Para 21. Hence, it is the value of the goods for the purpose of taxation which will be involved in the present appeal. Para 25 then, my lords. As far as the case in hand is concerned, the issue is involved in regarding interpretation of exemption notifications dated so and so, which will have the effect of valuation of goods for the purpose of levy of duty. Hence, appeal before this court will not be maintainable. 26, for the reason mentioned above, in our view, appeal before this court against the order passed by the tribunal will not be maintainable, as the jurisdiction to entertain the same would lie before the Honorable Supreme Court. Squarely on the similar point, my love, this is also on value addition.
So the orders are same orders, the two impugn order or a different order?
While the commissioner
Same,
passed
same
it was
common
an order.
order, common order by the SESTAT, different order by the commissioner.
Different order by the commissioner, same order by SESTAT.
Common order, my lord.
Common order.
Lordship, I want to place two paragraphs of that judgment, 2019.
Yes.
Paragraph probably 18, it will start from we are of the considered view.
18.
Probably 18, probably it will be 18. It start from the word we are.
Yes, yes.
We are of the considered view that the legislature has carved out only following categories of cases to which it has intended to give special treatment of providing an appeal directly to this court. 1. Determination of question relating to rate of duty. 2. Determination of question relating to the value of the goods for the purpose of assessment. 3. Determination of
Determination of a question relating to a rate of duty.
Rate of duty.
Then
Lordship, I may be allowed.
just let us go understand. We don't just read like a.
Because Lordship here.
So out here, second one is also determination of a question
Of relating to
a valuation of goods for the purpose of assessment. Then
Lordship, third, determination of question relating to classification of goods under the tariff and whether or not they are covered by the any exemption notification. Then next paragraph. Reverting to the present case, it could clearly.
have you got this judgment with you?
No, my lord.
2019, 9 SCC. 2019, 9 SCC, page 563.
563.
SCC, yes.
SCC, huh? 2019, 9 SCC, 563.
Merit for the law.
Yes.
Reverting to the present case, it could clearly seem that the only question that is involved is whether the SSC has violated the condition of the exemption notification by not utilizing the import materials for manufacturing of the declared final product and was therefore liable for payment of duty, interest and penalty. Neither any question with regard to determination of duty, rate of duty arises, nor question relating to valuation of goods for the purpose of assessment arises in the present case. The appeals also do not involve determination of any question relating to classification of goods, nor do they involve the question as to whether they are covered by the exemption notification or not. Undisputedly, the goods are covered by the said notification. The only question is to whether the SSC has breached the conditions which are imposed by the notification for getting exemption from the payment of the custom duty or not. The appeals do not involve any question of law of general public importance, which would be applicable to a class of category of SSC as a whole. The question is purely say between the parties and is required to be adjudicated upon the facts available. Lordship, here Lordship seen that they are entitled to exemption under notification 32 Lordship. There is a condition prescribed that they have to submit their financial statement of the each unit.
They are entitled to?
They are entitled to special rate under notification.
Edition of the product.
Yes, Lordship. It called the special rate.
Under which one? Under chapter 38 or 34?
Lordship, the notification 32 of 99.
32 of 99?
Yes, sir.
They are entitled to how much?
Lordship, they have,
According to you.
they have to file their financial statement.
No, according to you, how much, what is the value addition?
That can be
The rate for value addition rates, how much are they?
be determined after looking after their financial statement and
So they are entitled to a certain amount.
yes, they are entitled to a certain.
Then
Now our question is that they file a single application for multiple units. So it is
they
difficult.
filed a single application for multiple units, getting the value, special valuation.
Yes, sir. So now
Valuation, addition rates, whatever.
there is no question of determination of any tax.
Huh?
There is no question of determination of any duty payable to them.
He's not on duty, he's on the good, value of the goods.
Lordship, that is I am submission because there is interpretation of notification.
Huh?
There is an interpretation of notification. And Supreme Court says that when there is a
Changing your stand.
no, Lordship.
So you said your entire case was that they have submitted one application for multiple units.
Yes, Lordship.
You're saying you're talking about the notification not being applicable.
Because they are entitled to the exemption, the specific.
According to you, they're not entitled to the notification of 99.
No, they're entitled to under 32 of 99 law.
Then?
Because they have, as per notification, they have to submit the financial statement of each unit. Unit wise. Then after the commissioner has to determine the at what rate they are entitled to special rate. Because they file single application for 2 units. And it is difficult for the commissioner to determine the special rate. That is my question in short words.
So at the end of the day, the issue is whether it should be 2 applications or 1 application.
My lords,
No, according to you, it should be 2 applications.
Yes, sir.
There should be 2 applications for the 2 separate units.
Yes, sir.
To come to a rate which is to be applicable.
Yes.
To the petitioner.
Yes, sir.
So what does it boil down to? It boils down to determination of rates.
Yes, sir. Determination, Lordship.
Huh?
Is a
May I make
interpretation.
Yes. What?
First thing, my lord, there are, again, I will reiterate, there are no multiple applications. The substantial question of law is only about clubbing and appropriation. It is not saying that there is multiple applications. We have made multiple applications, that is evident from the 2 orders of the commissioner. Had I made 1 application, the commissioner would have said you have made only 1 application. That every unit has made a separate application is evident from the 2 appeals which are before my lords. So there is no question of multiple applications being filed. The only question is the value at which this application has to be arrived at. We have made multiple applications. Number 2, my lords, with regard to the Supreme Court, with my learned friend has cited, the eligibility of the exemption notification is not the case here. As he has pointed out, we are eligible to the exemption notification. The question is the value at which we will get it. The judgment of the Honorable Supreme Court in Motorola, my lords, is regard to whether in case of eligibility of the exemption notification. We are not saying whether we are eligible under the exemption notification. That they are also
That is not the issue here.
They are admitting that we are eligible. The question here is under the exemption notification, I am eligible whether I will get a lesser value or I will get a higher value. This very question, my lord, is valuation, my lords.
And you have got and you have been given a lesser value.
I have been given a lesser value and I have got a higher value from the.
Their application was rejected.
Application was
Rejected. And lots of reason has been specified in paragraph 2.3. Why their application was rejected.
The paragraph talks about appropriation, my lord. It does not talk about multiple applications. The 2 words are not interchangeable, my lord. We have made multiple applications per unit. The commissioner has only said that you have
rejected. Why was it rejected? Your application?
My lords, they said that the value which you have mentioned, my lords, the notification talks about the mechanism at which you will arrive at the sale value. My lords, can I submit a compilation so show the notification so it's clearer to my lords?
Yes.
I will just submit this notification 32 of 99. I'll ask my colleague there to submit this notification.
Yes. No, take your time. We want to understand the case because
my lord, very well. My lord,
it's not something that we do it every day. So we are learning also. Yes.
My lords. My lords, first of all, let me address the paragraph on the commissioner's order, which my learned friend is relying upon.
Yes.
Paragraph 2.3 of the commissioner's order. Page 24, my lords.
Of which appeal?
Appeal 1.
Appeal 1. Just 1 minute. There is something unclear. Yes, page?
Appeal number 1 of 2025, page 24, my lords.
24, yes.
My lords, para 2.2 and 2.3.
Yes.
I find that the appellant company is having multiple units and the goods manufactured in multiple units are transferred through agents for sale to customer. Thus, the actual value of sales of the products manufactured in a particular unit is not determinable. What does this mean, my lord? From the factory, we are moving our goods to depot. Since we are moving to our own depot, there is no sale. To our own depot, we are not selling the goods. We are moving it without any valuation. From the depots, the goods are sold. So when one depot is receiving goods from multiple units, the sale value which I have to arrive at for that unit, I cannot achieve that. So what am I doing? 2.3, my lords. The exemption under notification 32 of 99 is applicable to a unit located in the area specified under the said notification. As such, the benefit of refund at special rate representing actual value addition of the particular unit is only available. Special rate representing actual value addition in respect of a unit can only be determined on the basis of actual sale value, actual cost of raw materials and packing materials consumed in that unit, actual value of convertible fuels consumed in the unit, and actual value of opening stock and closing stock of finished goods lying in the unit during the preceding financial year. In the present case, the appellate is determining sale value by way of allocation stroke apportionment. It does not say application. It by way of allocation of apportionment of the total sale value of the company having multiple units. On the basis of excise duty paid by the unit, sale value determined on the way of allocation apportionment on arbitrary basis cannot be considered sale value. So what does this mean? We do not have an actual sale value because there is no sale taking place from our factory directly. We are sending it to our depot. From the depot, it is being sold. But one depot is not receiving goods from only one factory. They are receiving from several factories. So we have rationalized it. We have taken the weighted average. We have taken for one product received from 3 factories, we have taken the average and we have arrived at the sale value. What does the provision of law say, my lords? My lords may now kindly take my compilation.
No, then come to the next part. Page 25. Then he says, thus I hold that the special rate representing the actual value addition. So in respect of the applicant unit cannot be fixed in the absence of actual figure.
Yes.
So basically he's saying that because there are no actual figures pertaining to each individual unit, and as you have given a consolidated sale value, they cannot come to a finding as to the actual sales that you have made pertaining to each particular unit. Correct?
Correct, my lord.
Then,
So because there is no sale taking place from my factory, the unit over here is my manufacturing unit. The factory is not doing any direct sales. The factory does not do direct sales.
correct. No,
They-
yes, so you're sending it to your CNF agent.
Through my agent, I am sending it through my depot. From where
Okay.
sales take.
So your depot is your carrying and forwarding agent, no?
Through my agent, it is going through my CNF agent, carrying and forwarding agent. It is going to my depot.
No, no, it doesn't say depot. It says here, CNF agent for sale to customer. It doesn't say depot.
Yes, my lord. But the CNF agent is the depot, my lords.
Then?
Yes, my lord. CNF agent is my depot.
So?
So since there is no actual sale happening from my end, from the unit per se. So suppose there are 10 units, my lord. I am taking the consolidated figure of the 10 units and I'm arriving at a weighted average. The mechanism of the value addition, that is in dispute.
We will deal further clarified from paragraph 1 and 2, page 23. I have carefully gone through the submission of the applicant and the available records. I find that the applicant submitted the application for special rate along with a certificate of value addition based on their unit-wise balance sheet duly certified by their statutory auditor and copy of the audited balance sheet within the time as specified in the notification. I find that the sale value declared in the unit-wise profit and loss do not tally with the sale value declared in the monthly VAT return of the relevant year. As per the unit-wise profit and loss, sales of the unit during the financial year 2009 and 10 is rupees so and so. Whereas as per the monthly VAT file during the financial year, it is sale value is rupees so and so. Thus, the month-wise detail of the sale declared as per the monthly VAT return is so and so.
So out here it is unit-wise balance sheet. It is not a consolidated balance sheet.
Lordship, yes.
Then you're saying multiple application. You're saying it's a consolidated application.
Lordship, paragraph 2.3, 2.2. And 2.2 and 2.3. And my learned friend has submitted, they have submitted one application. Learned friend has make submission. They had submitted one application, consolidated application, not separate application.
No, my lord, that is not my submission. I have made separate, my lord, we are once again going back a step back. We have not submitted one consolidated application, consolidated application. We have submitted different applications for different units.
Let's say, allow me some time to produce original records. Let's say verify.
To show what?
So whether this is a consolidated application or single application.
How does it matter?
Because let's say the matter rests on the.
You see the discussion and finding based on the unit-wise balance sheet.
And my lord, the question of law is also not that consolidated application has been made. That is not their issue in their appeal.
Whether my learned friend is harping on the point whether the appeal lies to this honorable court or not, or he is contesting on merit. If he is contesting on merit, then lordship is to consider substantial question of law. If it is there, lordship then will be admitted or appeal will be dismissed.
My lord, that there is separate application that is again available from the.
Just a minute.
Unit 6 has filed the application. Mohammed Unit 4 has filed the application. First paragraph.
Okay. Where is this Hindustan Unilever Limited judgment?
It present is not available. It was passed by the CSET catalog. The relevant,
That is passed in 23.
yes, Lordship.
Then
But
you are
Lordship,
relying upon it and you don't have it.
No,
This is a
Lordship.
substantial question of law.
the tribunal relied on that. We said that this is not applicable in the present case.
This will not do.
And Lordship, page 42, the
We will dispose it of. Yes, what else to be shown here?
I'll just show regarding to the repeated reliance that multiple applications have not been filed. The commissioner order, my lord, in appeal number 1 of 25, page 17 is the beginning of the order.
Yes.
In fact, page 17, both the appeals.
Yes.
Messrs. S.C. Johnson,
Yes.
Private Limited, Unit 6, Dag number so and so, having central excise registration number, Manos ends in MXM003.
Yes.
Manos, may kindly see the other appeal. Page 17 again.
Yes.
SC Johnson Private Limited, Unit 4. This is a different unit, my lords. Excise registration number ending in MXM 004.
Have applied. Okay.
I have applied, my lord. Different applications have been made for different units. This is evident from the commissioner's order and the record. There's no further record required for this.
Yes. Okay. So this is a separate application. It's clear. Page 70. Your commissioner's order.
Lordship may please to see further.
There's nothing to see further. What is it further?
My lord, I believe the submission was if separate applications have made, the appeal may be disposed.
Yes, that's what he said.
No, it is there, Lordship. Then I have no case, Lordship. Lordship may pass an order, Lordship.
That's what, because you had said
No, Lordship, the question is, Lordship, they have raised a preliminary objection that appeal does not lie to this honorable court, this will lie to the Supreme Court. If they are contesting on merit, Lordship, allow me some time, I'll satisfy Lordship whether we have a case on merit or not.
No, so that is no, all right. I think we have gone enough. Heard.
Responding to their submission, I was not my preliminary submission remains the same. Because the averment was that multiple applications have been in, therefore I only pointed out for my lord's convenience. I am not
Heard Mr. S.C. Kyal, Learned Counsel for the appellant. Also heard Mr.
D. Sen, my lords.
D. Sen, Learned Counsel for the respondent. The present Central Excise Appeal is filed against the impugned judgment and order passed by the Honorable Sestat, Kolkata. Wide final order number 7656-76557 of 2024, dated 6/8/2020, concerning excise appeal number 71477 of 2013. The case revolves around MSSC Johnson Products Private Limited, a manufacturer located at Unit -06, dark number 13 KA, Bamudi Maidan Industrial Area, Guwahati, Assam. This company produces mosquito repellents and cleaning preparations, which was availing the benefit of area-based exemption under notification number 32/99-CE dated 8/7/1999, as amended by the notification number 17/2008-C dated 27/3/2008 and notification number 31/2008-C dated 10/6/2008. Full stop. Not full stop, comma, hereinafter referred to as the exemption notifications. Any discrepancy in the facts, please let me know. Okay.
Yes, ma'am.
The appellant's contention revolves around the issue of fixation of special value addition rate for the financial year 2010-11. The appellant's unit 6. Should I make it into a common order, I think? Made a common order.
That will be better. So instead of unit 6, unit 6 and 4 both can be mentioned.
So earlier we had said no, final order dated 7/6/5.
Yes, ma'am, it's a common order. Yes, ma'am.
7/6/556-76557 of 2024 dated 6/8/2024. You've got no?
Yes, madam.
Concerning excise appeal number 7147 of 2013. It is there. It is already there. That is already there. And final order number 71476 of 2013. No, 71476 dash.
My lordship, those are the appeal numbers before the SESTAT. The final
Okay,
order
okay. Final order. What is the final order?
at the bottom of the page 76556, 76557.
Okay. Of 2004 dated 6/8/2004. That is already there, huh? Concerning excise appeal number 71476 of 2013, and that one is already there, and 71477 of 2013 is already there, huh? Full stop. Okay. So next para, what have I said? Huh? Huh? The appellant? It's in the. But please read from the beginning. No, I think I'll give my dictation to this. Yes, madam. I will give you dictation. I'll dictate. No, I'll give it to you. Heard Mr. S.C. Cat, learned counsel for the appellant in both the appeals. Also heard Mr. D. Sen for the respondent in both the appeals. The two appeals are being decided by this common judgment in order. By this common order. Next paragraph. The two appeals have been filed by the Commissioner of Central Excise and Service Tax against the impugned judgment and order passed by the Honorable Sister, Kolkata, in final order number 76556 76557 of 2024, dated 6/8/2024, concerning excise appeal number 71476 of 2013 and 71477 of 2013, which was disposed of by the above common order. Next para. The case revolves around the issue of whether the respondents are eligible to be given the special rate of value addition for their products, for their manufactured products in terms of the exemption notification. No, in terms of the exemptions, in terms of the area-based exemptions granted under notification number 32/99-C dated 8/7/1999, as amended by notification number 17/2008-CE dated 27/3/2008 and notification number 31/2008-CE dated 10/6/2008, hereinafter referred to as the exemption notification. The next para. The respondent, who is MS.SC Johnson Products Private Limited, is a manufacturer of mosquito repellents and cleaning preparations having unit number 06 and unit number 04 and unit number 06 in DAG number 13 KA, Bamuni Maidam Industrial Area, Guwahati, Assam. Next part. The apparent contention revolves around the issue of fixation of the special value addition rate for the financial year 2010-2011. Inasmuch as the learned sister in the above impugned orders had, where is that page? In orders. had held that the methodology for arriving at the sale value from the audited financial statements of the respondent company, comma, by apportioning the same to the respective units on the basis of stock transfer ratio had been accepted, and special rate for special rate of value addition as had been fixed in the exemption notification would have to be provided to them. Correct? Mr. Sen, correct?
Yes, ma'am.
The learned says that thereafter set aside the original orders of the commissioner dated dated
21 is 20th June 2013, the other is 21st June 2013.
dated 20/06/2013 passed by the Office of the Commissioner, Central Excise and Service Tax, Guwahati. In relation to Unit 06 and order dated
21st June
21/6/2013
13.
in relation to Unit -04. Next paragraph. The respondents unit 4 and 6 thereafter filed two separate appeals before the Honorable Sestat, Kolkata. Acha, before that, the learned commissioner held that the learned commissioner rejected the respondent's application for fixation of special rate representing actual value addition under the exemption notification Pustaka. Next paragraph. Next paragraph. Pustaka. Excise appeal number 71476 of 2013 pertaining to Unit 4 and excise appeal number 71477 of 2013 pertaining to Unit 6. was subsequently decided as stated above. Next para. The learned counsel for the appellant submits that the special rate of value addition as provided in the exemption notification required separate applications to be made by the respondent company. Instead, the respondent had submitted a consolidated application for the two different units for availing the exemption benefits provided in the exemption notification. That's the only ground. Is there any other ground you have taken?
We have proposed three substantial question of law.
Is that the only ground you have taken that he just submitted one consolidated application?
Here, Lordship, I take.
Yes, is that the only ground he has taken?
My lords, he's argued that one ground, but in the appeal, there are three questions of law which have been raised.
Good stuff. Next para. The learned counsel for the appellant has also raised three suggested substantial questions of law, which are as follows. 1, 2, 3. Take it down. Anything to say on these three substantial questions of law?
My lords, he has not argued that, but if I have to make submission, I will.
I think because he has put it in writing what to do. You say something about this?
With regard to the first question of law, there is no argument raised whether you can, whether the basis which the CSTAT has relied upon for the application of sale value, that is correct or not. To that, I will say that it is a question related to valuation. That is the first question.
Number two.
Number two is whether the decision of HUL is applicable. My lords, he has not been able to produce the judgment of HUL and whether that has been challenged, has been set aside by a higher forum till date. So if the tribunal has followed its coordinate bench order, that is the rule of law. They cannot follow unless this order has been set aside by a higher forum. That has not been established before, my lords. This HUL.
Next.
My lords, the question, the third question and the first question are similar to, they will have the same answer.
Okay. Next. The learned counsel for the respondent company, on the other hand, submits them a bare perusal of the orders of the commissioner dated 20/06/2013 relating to unit 06 and order dated 20/06. The same. 20/06. Both are 20/06.
Same date, Lord.
Same date, both are same date.
Yes, Lord.
Commissioner's order, both are same date.
Whereas the tribunal order records a different date. I might be mistaken, my lord.
No, both are same date. No?
Same date.
What have I said?
Yes, sir.
No, wait. This is commissioner. Mm. 20/0/30, but the unit is not shown here.
The unit is mentioned in both the orders, at the
Where?
operative portion as well as in the beginning of the commissioner order.
Where? In this appeal 2, where is it shown?
Appeal to, my lords. Appeal to page 24, my lords.
Lordship, it is mentioned, Lord.
At the bottom,
24.
filed by SC Johnson, Unit 4. At the bottom,
Okay.
It is mentioned in both the orders.
Okay. Same date, huh?
Lord.
30 pertaining to unit. No, and this one will be 4. Huh? What have I said? And 20/06/13 relating to unit 4 clearly shows that separate applications have been submitted by the respondent for exemption for grant of special rate of value addition in terms of the exemption notification. The learned counsel for the respondent for the submit that the present two appeals are not maintainable on account of section 35G of the Central Excise Act 1944 as the issue pertains to a question having a relation to the rate of excise, no, relation to the value of goods for the purpose of assessment. He submits that the issue raised in the present appeal will lie directly to the Honorable Supreme Court under Section 35L of the Central Excise Act 1944. As the issue pertains to the quantum of exemption available to the respondent company under the exemption notifications. Next. The learned counsel for the respondent further submits that question number submits that the proposed the proposed substantial questions of law number 1 and 2 have a relation to issue of quantum of exemption available to the respondent company under the exemption notification. And as such, Section 35G and 35L of the 1944 Act would apply. With respect to the substantial question, suggested a substantial question of law, number 2, he submits that when the appellant has not annexed a copy of the said order or produced the same in the court today, comma, he has got no comments to make on the same. However, there does not appear to be any infirmity with the Honorable Sestet following a covered matter, comma, as it is bound by judicial discipline to follow a decision of a coordinate bench. The hour submits that the decision of the stat as provided in substantial question of law number 2 cannot override the provisions of section 35G and 35L of the Central Excise Act 1940. I have heard the learned counsels for the parties. Section 35G and 35 is reproduced here in below as follows. Next, as is made abundantly clear in the above two provisions of law, an order which is relatable to the determination of the question having a relation to the rate of duty of excise or to the value of goods for the purpose of assessment would have to be decided by the Supreme Court as an appeal with regard to the said issue is barred, cannot be decided by the High Court. Full stop. The present issue raised by the appellant pertains to whether the exemptions and the rate of exemption to be given to the respondent can be decided. No, what have I said? Pertains to the grant of exemption, rate of exemption. In terms of the exemption notification. When the issue at hand relates to an order passed in appeal by the Honorable Sestet in relation to the determination of a question having a relation to the rate of to the value of goods for rate of value addition. For value addition, for value addition. The we are of the opinion that the said order of the appellate tribunal would be governed by section 35G and 35L of the CA Act 1940, CA 1944. The rejection of the petitioner's respondent's application by the commissioner on the ground that the sale value used by the appellant, used by the respondent, used by the respondent for determining the value addition were not actual, but estimated through internal apportionment, and that in the absence of actual sale values attributable to individual units, the real extent of value addition could not be accurately determined. The commissioner had accordingly concluded that the conditions necessary for fixation of a special rate of value addition been fulfilled. The learned Sestat had, however, opined otherwise in respect of the claimed special rate of value addition by the respondent. The stand of the appellant is that the learned Sestat had erred in allowing the appeals despite the lack of actual unit-wise sale data, which was essential for calculating the true value addition and determining eligibility under the exemption notification. Full stop. On a consideration of all the issues and all of the issues that have been raised before the commissioner and the learned Sestat, we find that the issue pertains to the exemptions pertaining to the rate of value addition, which may or may not be applicable to the respondent in terms of the exemption notification. As such, we are of the view that the orders being a determination of the question having relation to the rate of duty of excise, the rate of value of goods for the purpose of assessment, the present appeal is not maintainable in terms of section 335G and 35L of the CA 1944. The appeal is accordingly dismissed.
Lordship, ST may be directed to return the original documents for filing appeal before this.
The registry and is permitted to return the original document. No, but then we have all made this thing, no? Part of our
Lordship, the registry will keep the photocopy and return because
the
Lordship.
CIS. It's all in the CIS now. It's all uploaded. You file an application, see, ask them. I will not pass an order because you see everything is now it's in the system. You apply for a copy.
Lordship, because Lordship here, Lordship is delegators to avail remedy under section 35L. Under the Lordship, because question of limitation will again come.
Huh?
Question of limitation will again come.
Maybe.
But in all the orders passed earlier, Lordship directed the registry to return the original copy, certified copy.
I don't know. You ask an application. Let the registry find out because I don't want to, without knowing what is going to be the effect. I don't want to pass an order. I'm being careful also. I will be disposed of accordingly also. To IS. In view of the order passed in the main appeal, they dispose of accordingly. Huh? Yes, Mr. Sen, we have finished.
My lords, I apologize. There was some technical error. I got logged off. I deeply apologize, my lords.
No problem, no problem.
And I'm grateful, my lords, for the long and patient hearing in this matter with my lordships. I've been
No,
granted.
you see, even I'm learning. That's all. Hope I've not passed the wrong order, that's all.
I'm deeply grateful.